Hello and welcome to our explainer about post-termination restrictive covenants. Do you have after you leave terms in your employment contract? They're also known as post-termination restrictions, restrictive covenants, or non-compete clauses. The devil is in the detail. I bet that if you do, you've forgotten all about them. You signed your contract when you started, filed it away and never gave it another thought. You might not even have read your employment contract when you signed it. These terms tend to only rear their ugly heads when you've been offered a new job and want to leave your current employer. You might have just been offered your dream job, but you need to make sure you're allowed to accept the role, or if your current employment contract might have some restrictions. First thing to do is check your written contract. You don't want a nasty surprise. Post-termination restrictions can cover many areas. They fall into two main groups, the obligations that apply forevermore and the ones that tend to apply for a set period of time after you leave. The most common forever obligations are confidentiality, which is keeping your employer's data and information secret, especially top-level trade secrets and client lists, and not using or disclosing it to anybody else. And then there's intellectual property, ensuring you don't use materials belonging to your employer for anybody else, even if you created them. And these common examples of fixed-term obligations, which are usually for a set duration, such as 3, 6, or 12 months. First, we have not competing with your current employer. Then, not poaching clients, customers, suppliers, etc. Then we have a term which is called non-dealing, which doesn't allow you to deal with clients, customers, suppliers, etc. when you're in your next job. And not enticing away. So this is not encouraging clients, customers, suppliers to stop doing business with your current employer, or rather your former employer, because they will apply after you've left. And then we've got not poaching colleagues for the new employer. You need to understand what these terms mean, how they apply to your situation and industry, and whether they could stop you accepting a job, working in the same industry, or even earning a living at all. They can sometimes be very problematic. Do you have to comply with them? Well, in many cases, they won't be enforceable, but they're intended merely as a deterrent. This is a complex area of law, and not all restrictions are created equal. To be legally enforceable, post-termination restrictions are subject to a legal test of necessity and reasonableness. That means if your employer wants to hold you to them, they have to show that those particular restrictions are needed in order to protect the business, and that they don't go too far in scope, breadth, area of operation, because sometimes they're based on a geographical area, and duration and number. Every case is different, and the way that the courts look at it will be to understand that particular situation. So what can your employer do if you ignore the restrictions? Well, if you do break them, that might constitute a breach of contract. Your by now former employer may do nothing. They may not really care that much if you don't comply because you aren't important enough to the business. Sorry. Or they may simply have a policy that the restrictions are intended as a deterrent, but they won't go as far as suing you if they breach them. Of course, they also have to find out that you've breached them. And this may be more obvious in some industries which are very niche compared to others. If they find out and they care and they decide they want to do something about it, it may be because they're super angry or nervous that their business might be damaged, or they might just want to set an example of you. If this is the case, they will probably get the company solicitors to write to you, and potentially also your new employer. They will write a very strong letter setting out the breaches as they see them, and demanding that you stop doing it. This is what is generally referred to as a cease and desist letter. They will also usually demand that you sign legally binding undertakings, promising that you will comply with them from now on. And they may demand evidence of any information that you have used in your new job. If you agree to those undertakings, it will probably be the end of the matter. But if these attempts to protect the business don't work, or if the company decides it's so urgent that they'll skip that stage, then they may apply to the court for an interim injunction. That's a court order telling you to do or to stop doing something. You may be told about the court application in advance, and the hearing is usually held at very short notice, or the company may apply without even telling you if they can show that it's a real emergency and that their business is at significant risk. This is called an ex parte application. Your new employer may get dragged into the litigation if they are accused of inducing you to breach your contract. You may lose your new job over it because you're costing them money and trouble. Or the new employer may support you in this because you're highly valuable to them. In many cases, if the employer is successful in obtaining an injunction, then you are likely to have to pay their legal costs of bringing the case. After an interim injunction is issued, there will be a full hearing at some point in the future where evidence is brought by both parties, and the court decides whether that injunction should be permanent or should stop at that point. All of this hassle may mean that word gets around and your reputation is damaged. It could affect your future employment prospects. So what can you do to resolve things without getting sued? Firstly, get legal advice on the restrictions so you understand properly how they affect you. They may not even be problematic if you're moving to a different sector, for example, or you aren't client-facing. If, however, they're likely to stop you moving on from a job or accepting that dream job, or if you just want peace of mind, then talk to your current employer. Lots of companies will take a pragmatic view and will agree to reduce the length or scope, for example. This new negotiated agreement will be a variation of contract and is more likely to be enforceable, which means both parties have certainty about the situation and you are more likely to comply. For example, 3 months worth of recently agreed restrictions that the company have confidence you will honour is way more useful to an employer than 12 months of restrictions in a contract you signed years ago, which you don't want to comply with, which may not even stand up in court. After all, a bird in the hand is worth more than 2 in the bush. So it's often a good idea to talk to your employer that you're leaving and see if you can renegotiate those terms. But if things have gone further and you think you're in trouble, you may have recently resigned and you've received a letter from your current or former employer about their solicitor, reminding you about your obligations, perhaps accusing you of breaching them, demanding you sign undertakings, or if you've been sent court papers, then contact us without delay on this number. Things can move quickly to court, even without you knowing, so you need to deal with this very promptly. The expert employment lawyers at Rebel Law can help you respond to any allegations, navigate through the process, and generally help you get it sorted. So if you need urgent advice on this sort of issue, please do get in touch with us.